think I know how anxious you all are to get the results. Maybe we've just decided we can't decide and we'll all go home, but I've asked Judge Keeton and Judge Kearse to make at this time some general comments about the argument. And if you can bear with us just a few more minutes before we announce the decision, we'll indulge in that. Judge Keeton, will you
now
tell us what you have to say?
You will understand that my first role is just to extend the suspense for a while longer, because I'm not going to say anything about the results, but only an opportunity to express my appreciation for the opportunity to be back here again. I've gone through some interesting experiences recently. Not too long ago, I found myself frequently listening to arguments, both trial and appellate, and trying to screen out of my mind the substance of the arguments in order that I could make some evaluation of the performances and give students some useful critique as well as other kinds of evaluation. Then I shifted to another job, and I found myself now and then forgetting that I was supposed to be listening to the substantive content instead of evaluating the performances before me. Now I've been at that other job long enough that I have become tutored to remember it's the substance you're to be thinking about and not how well these lawyers are doing. And now here I am again this evening, and I found the argument so interesting substantively that sometimes I forgot that I was supposed to be performing another role also. But another feature about this experience that I want to express is that I do find it to be a special treat to be back in this familiar atmosphere where, as I remember it so well, students were always thoroughly prepared for every question. Now, with respect to the arguments this evening, I wish that all performances that I hear in that other job of mine were up to this excellence. Of course, I do occasionally hear some up to this excellence because some of my former students sometimes appear before me. And in addition, there are some excellent counsel who didn't even have the benefit of that instruction. But I would be entirely candid in saying to you, as I do, that my life would be easier in that other assignment if all of the performances were as good as these were this evening, and we do very much appreciate that. I think also when we come around to announcing those things that you're waiting to hear, and I'm postponing by every moment longer I speak, it is relevant to say that one of the things that makes that so difficult to decide is that counsel have different opportunities in a case because of the nature of the issues and their difficulty and the way the case comes before the court and so forth. And we do our best to make evaluations on that, but I especially commend all four of you because it did seem to me that you had quite different problems to address from your different perspectives and responded very well to the special features of the side of the case that you had. Thank you again for the opportunity of being here.
Judge Kearse?
Thank you. I have been judging moot courts now for about 20 years, 20 consecutive years, and on every occasion in which I have sat on a panel with a real judge, I've heard him tell the, and usually it has been a him, tell the participants that they are much better than the lawyers that usually appear before him in his courtroom. And until about a year and a half ago, I'd never really appreciated how true that is. And I must say that this is one of the best moot court arguments I have heard in my 20 years of judging moot court. It's a great pleasure to be here and to participate in these. And it's especially good to see new lawyers coming along who can respond to questioning, because after all, that's the main point of oral argument. It's an opportunity for the judges to ask you the questions that are really troubling them. And the more to the point you can be in answering the question, the greater assistance you'll be in having your point of view adopted. And if there's one thing that I would stress, it's really that everyone making oral argument should try very hard to listen to the question. And sometimes it's very difficult to do that because you're under a lot of pressure standing up there. And you have to be very careful to listen and try to figure out what it is that the judge is getting at. Because at least in the real world, that's the question that's really troubling the judge. In moot court, it may not be really troubling the judge. You may just want to see how you respond. But it's good practice for you to respond responsively anyway. But in any event, I thought that this was really an excellent argument all around. Thank you.
Well, I share everything that has been said by my colleagues here on the bench, and I would like to pay tribute to them, not just for what they did tonight, but because each is very distinguished in what he or she has accomplished, and I think they are ornaments to the federal bench. I say that without reservation for both. Well, there's another old saw that's said at moot court arguments, and that is that we're always pleased we do not have to decide the case on the merits, and yet after the argument we might wish we could decide it on the merits. The cases are made close and the arguments are close, and by the time oralists get to the end of the line in the Ames competition, it's a horse race. And as is so typical in our profession, in litigation anyway, someone always has to lose. But it isn't the end of the world, and show me any lawyer of whom it is said that he has never lost a case, and I'll be looking at a lawyer that has never tried very many. I think that you will look back on this experience as you get older. I certainly look back on the Ames competition of a long, long time ago and can remember everything that happened that night. I share what has been said in the comparison of your performance with that in other courts. I can only say, and I know that the two judges with me will agree, that each and all of the four of you will succeed in this profession. And it'll be discouraging at times, but you have what it takes and you'll get along. I rather suspect that you will never be so bored with an actual case as you must be with this one by now. You worked on it. Well, a couple of things about oral argument that you've heard. One is the desirability of answering questions immediately, directly. And at least in the court on which I'm privileged to sit, when you're down there, don't be upset if your well-prepared argument goes down the drain. That's a rude court, and I've told them many times it is. They talk too much, they ask too many questions, they ask questions at the same time. You're sitting out there in front of them quivering, and these 9 somber, owlish figures are staring down at you. And You must appreciate the fact that, as Judge Kearse pointed out, the questions often are asked because that question troubles the one who's making the inquiry, and he wants an answer. He wants his trouble to be alleviated. Or it may be something that's directed to Justice so-and-so down the bench. You may have seen, at least in one of the papers recently, the little squabble between the Chief Justice and Mr. Justice Rehnquist, when counsel had enough sense to say, "Don't get me in between," and didn't have to answer either question because they were really directing questions at each other. I think it was Robert Jackson, Mr. Justice Jackson, who said, and he says so many things that I meant that as a compliment, that if the time comes when you have an oral argument to make in a court of appeals before a district judge in a Supreme Court somewhere, and if you don't feel that it's one of the great days in your life, don't make it. I think that says a lot, and I have the feeling the four of you tonight certainly measured up to that. One other comment, I enjoyed Judge Keeton's questions because he was zeroing in many respects from the point of view of a district judge, and it is so true, and I know Judge Kearse will agree with me on this, that this is where your cases are won. You don't win too many of them only in the appellate court, the Court of Appeals, or in the Supreme Court. You win it in the trial court. This is when your record is established and when the facts are determined. I thought this case generally was a pretty good one. It's in a developing field of law. As you know, it's taken after the Upjohn case, and you were instructed not to look at the Upjohn case. I have to assume you hadn't. But that case was argued before us on November 5, and I will say it was well argued. It was argued just as well as you did it tonight. Now don't be mad at me because I say that, but it was a comfort to see as important a case as that one argued as well as it was by both sides. What the cases I worry about are when we have a situation where there's a superb oralist on one side and a terrible one on the other. A comment or two about the record. I was amused at cert being granted on October 3, 1980. We don't grant certs on Friday, and that was a Friday. As a matter of fact, it was the day before the term began. The second thing, somewhere buried in here are some remarks by Judge Wisner speaking of the parties as respondent. Respondent Imperial and Respondent Wade, both were appellants in the Court of Appeals, I think. But then we get ourselves mixed up all the time. I think in some respects the petitioners very effectively and strongly argued the demerits of the control group test, better perhaps than they argued the merits of any other test. Of course, they took the position that under any test they would prevail. What do you really think of the merits of this case? How would you decide if you were a judge on this one? Well, enough for me, and I just say again, as my colleagues have said, that it's been a most enjoyable evening. You've done a grand job, and in the year 2020, you look back on 1980. I have taken the liberty, and I suppose it's highly improper, but I have brought you, for what it's worth, a full set of the appendix and the merits briefs and the amicus briefs in the Upjohn case. I couldn't steal a second set, but if the four of you can share these, and if you're interested, here they are. It might be of interest to you to see how the professionals went at it. And of course, you had more issues than they did, but in any event, I'll leave it here and you can have those. Now, for the results. I'll never forget sitting one time on a moot court. I was not presiding, thank goodness, when the chairman announced the wrong winner. He announced the losers as the winners. See if I can read my own writing. The briefs, I understand we are to say which had the better on the briefs, and we have concluded that the petitioners have the better brief. On the oralist, we went around and round. That's what delayed us. But we have finally concluded that the prevailing oralist is Miss Kathleen Sullivan. That probably means, Ms. Sullivan, that you'll lose on the merits. So often that's true. And I think we're supposed to determine the winning team. And we have decided that the nod as to this goes to the petitioners. Thank you all again for a very instructive evening. I dare not comment on the merits of the Upjohn case, but you've taught me a lot. Good night.